The broadcast is now starting. All attendees are in listen-only mode.
And good morning, everyone. Welcome to the next in the series of the VTIC webinar series, our April webinar. Delighted to have so many, lots and lots of people on board. Delighted to have you on board. Thank you for signing on. Hopefully a few more come on as well. Today we're really rapt to present Risk Management 101, largely through our good friends at Adroit and also Proclaim. Dave Stott, the Senior Broker with Adroit, and Richard Thomas, who's the National Manager of Insurance with Proclaim. They're here to talk to us all through the Risk Management 101 exercise, and we'd encourage you to ask as many questions as possible. Even if it's got nothing to do or similar to what's being spoken about, ask away. Anything you ever want to know about your insurance or risk management, we've got the experts online right now to help you. So without further ado, I'll hand over to Richard and Dave to take over. And good luck, guys.
Thank you, Ian. Richard Thomas here from Proclaim. Very quick intro on us. We're an independent claims management company. We work extensively with Adroit in the industry and do a lot of work in this space. One of the things we do is work with insurers, but also with people who carry some level of self-insurance. So at the conclusion of the seminar, if you've got any interest in talking to us about that, we can certainly be in touch and happy to speak to you further on that.
Dave Stott here from Adroit Insurance Group. Obviously, we're a integral partner with VTIC, doing all things insurance and risk management. I'll hand over to Richard now to run through the sign your life away, making waivers and risk warnings work for you.
Thanks, Dave. Okay, so what we do know is that in the leisure industry, there's a certain level of risk in some of the activities that you undertake. So whether that be riding a go-kart or sledding down a hill or riding a pony, there is some inherent risk of injury, just as there is with most sports and leisure activities. That's often created a problem with people in terms of managing their risk and what their legal position is. And what we don't particularly want to happen is for you to be sued by people like Slater and Gordon and Morris Blackburn and Shine Lawyers. There are some ways that you can help manage that risk, and one of those ways is using waivers and risk warnings. So we're going to speak today about some of the tools that you have in your box there to help you with that factor. Okay, now it is important to know that leisure activities, as with any other service or good, is subject to the Australian consumer law. So that's a Commonwealth piece of legislation that applies around Australia, not just in Victoria. And what that does is implies guarantees of due care and skill into the provision of services. Okay, so the services, it also says that the services must be fit for purpose, so they must do what you say they're going to do. So a very simple example of that is you put someone on a pony, the pony needs to go and probably not be like a racehorse and disappear off into the distance and be unsuitable for a gentle pony ride. Now, the consumer law also says that you can't contract out of the guarantees that the law applies. So the law will apply regardless of what you agree with the person you're providing the service to. However, there is a carve-out, and the exception is recreational services. So that applies to sports, leisure activities, things like pony rides, ice skating, certainly things like motorsports. So in those circumstances, risk waivers can have some effect. So they can give you some protection under the law and some defence against being sued by the plaintiff lawyers or an action from an individual themselves. Now there's some conditions around that, and we'll go into those now. Okay, so what is specific to Victoria? So this is the way that Victoria applies and modifies the Australian consumer law. And there's some details around the form that signs and forms should take. So a warning and note should be included on any sign or notice given to a person receiving the services. So if someone comes along to your venue and wants to partake in the activities that you're offering, there should be warning signs available to them and a note on any form that they sign. A further warning and note should be included in any form given to that person. So what we're talking about is signs up on the entrance, say, to your facilities, often throughout the facilities as well, but also a warning in any form that you give them to sign prior to them undertaking the activity. It's probably, it may be seen as obvious, but it is important that they sign it before they undertake the activity and not during or after. Okay, so that's provided for in the Regulation 5 of the Australian Consumer and Fair Trading Regulations 2012, which you can find on with a bit of Googling, should you care to read that in detail. So what are recreational services? Well, they're sporting activities, which seems obvious. So, and that includes not just playing at your local footy club or tennis club or basketball club, but also professional sports. So that would include professional football. It would include, it's been tested in the courts, and it also applies to horse racing, things like motorsports, things like cricket, professional cricket would all be included in that. It also applies to similar leisure time pursuits. So it's something that we possibly wouldn't consider a sport per se, such as going down to your local fun park and going on a water slide or in a toboggan or things of that nature, would also be considered recreational services. And then they also include any other activities involving physical exertion or risk, as long as they're undertaken for the purposes of recreation, enjoyment, and leisure.
Yeah, Richard, so Ian here, I'll just quickly butt in again. Kate's asked a really good question here. Kate's asked about, what about a tour, a walking tour or something like that? Would you consider that to be a recreational service? How does that sort of work out?
Yeah,
thanks, Kate, for the question.
Yeah, that is a really good question. There's certainly, that's for the purpose of recreation or leisure, so I would consider that to be a walking tour, and to the extent that there was some risks involved in that, then it would probably be captured by that.
Yeah, even as just a simple walk, I think I'll just continue on from Kate here, just a simple walk around town.
Yeah, there's no reason why not. I mean, it's certainly the case that there would be some risks would arise in the context of that. So if we're talking about walking around a town, someone trips over a footpath because there's a crack in it, or gets run over by a tram, then there are some risks that would probably sit with somebody else. But the mere fact that you're supervising on that tour probably wouldn't be a reason that you would be sued.
Yeah.
And if you were, arguably there would be an ability to contract out of it by use of a waiver.
Sure. So the best thing is be covered, talk to your risk broker, and go from there.
Absolutely. I think in any given circumstances, and we can provide some details, we'd be happy to have a chat to give you some general advice around how that might come out. And certainly the guys at Adroit can give you some more specific risk-focused advice on that. That's certainly their very much in their sweet spot.
Right.
If I use a slightly different example, and we've got a more strenuous form of walking, so we're talking about bush walking, up in some hills or in the mountains, then that would very much fall within the ambit of what's considered here.
Can you also tell us, I guess, what doesn't fall into that category of recreational services? Some clear examples, or is it grey?
It's certainly a matter for argument, but I suppose certainly if you're, it wouldn't apply really to the people who are walking in terms of guiding, because they're employed, and the duty of care, so the responsibilities owed to them by the employer, are quite a lot higher because they're in an employment situation. If, let's say, for example, someone was abseiling down the outside of a building to clean the windows, this sort of protections wouldn't apply. You wouldn't be able to contract out of those. But if I take the same activity, abseiling, on an adventure sport basis, and we have seen people offer abseiling down the outside of buildings for fun, leisure. Some people might not consider that fun, but some people do, or certainly abseiling down a cliff, then yes, absolutely, that would be captured. That would capture that instance. So sometimes the difference will be the basis on which you are undertaking that activity, and that's where the provision is undertaken for the purposes of recreational enjoyment or leisure, rather than for the purposes of work.
Yeah, well, many of our members offer adventure activities, either soft or hard adventure activities as part of their services, so very, very appropriate. Thank you.
But something as innocent as playing paddle tennis or softball tennis or deflated tennis, that would be captured by that. So someone just tripping over their feet or stretching too far for a shot, there have been attempts by people to sue for that in the past, but that could certainly be captured by this and could be managed by way of a waiver or warning sign.
Sorry, I'd ask another one. But Phil's just come in and asked about, no, he's a motel operator, I think, Phil. He's asked about, he's got a table tennis area as part of a recreation room he's got at his motel. Is he covered there? Does does this sort of thing cover him?
Yeah, there's no reason why that could be covered. More provisions, though, that you would need to appropriately have warning signs on display. We'll go to some details about that in a minute, and they would still need to sign the waiver.
Right. Thanks, Phil.
But yeah, some really good questions in terms of what the ambit is. All right, so just to flesh that out and give some examples, as I said before, professional sports are included. And also activities undertaken for the purpose of a business if the business is supplying the recreational service. And there's a case that illustrated that, and I can provide further details subsequent to the seminar if people are interested. But that was actually a motorcycle skills training session. So I was actually teaching people how to ride a motorbike well. So it was the learning of it as opposed to the participating of it. But because it was designed to assist people to ride motorbikes, and those motorbikes could be ridden out in the bush or on a motocross track or out on the road for leisure, that was captured by this, and the use of risk waivers and warnings were held to have effect and provided protection to the people offering it. The one to illustrate where it does sort of end, it doesn't apply to, and this is actually a case that we were involved in as a company. We defended a club that provided an ice skating rink. We won the case, but on this basis, the court found that, not on the basis of this defence, but the court found that this doesn't apply to activities preparatory to the activity. In this case, someone was walking down steps with their ice skates on before ice skating. So at the point they got onto the ice skating rink with their skates, had they fallen over and injured themselves then the warnings and risk waivers could have applied, but not before that point, so at the point that they laced their skates on and started walking down the steps.
Good. Actually, just one quick, Kerry has asked a question. Thanks, Kerry. What warning signs are required on buses, except for those covered as an accredited bus, where the bus is used to take people for recreation activities? So it's warning signs on the transport vehicle.
On the bus. Okay, well, that's a little bit of a challenging question. The short answer is get some legal advice. But it's slightly complex because when the bus is in motion, and it does change a little bit state to state, but when the bus is in motion and use, it's actually covered by the Transport Accident Commission here in Victoria. And that's a completely different set of legislation, and I'm not sure, I don't think the risk waivers would have effect in that instance. There are some scenarios where you're getting on and off the bus where a risk warning could have some sort of effect, but certainly not if it's involved in a traffic accident.
Yep. In the state of Victoria, I know we do a lot of bus companies, and regardless if the bus is moving or not, it's an issue for the legislation through
the TAC.
Through the TAC, we pay registration. So even if an incident happens when the bus is parked, it goes through TAC, and I would doubt a waiver would come into effect there.
No, and that's a no-fault scheme anyway.
Yep.
So if you are injured or can't work because of an injury that happens in the course of transport on a bus, then the TAC is going to provide you with some benefits there.
Yeah, Kerry, if that's not clear, we'll have Dave's contact details up at the end of the session, or give me a yell at any stage, Kerry, and I'll let you know what Dave's details are. Because I think the really thing already that's coming out of this is, wow, you need expert advice.
Yeah, that's right.
To talk about the sort of risk that's out there, just to make sure you're covered so you don't get Mr. Slater and Gordon, an ambulance chaser, knocking on your door.
Yeah, that's
talk to the experts. Thanks for that. Actually, just another quick one. No, we're fine on that. We're good.
Signs about activities would occur once you get off the bus. Well, yeah, that's the appropriate place to post your signs. So hopefully most people are going to be safe enough getting from the bus to the entrance, but at the entrance or inside the park is where you'd be posting your warning signs. Having said that, I can consider one scenario which would be if you've got anybody in the ski industry, obviously someone getting off the bus and on the way to their slopes could certainly slip over. So there may be some assistance in providing some warnings about what seems obvious to us, that may be slippery when you get to the snow. Okay, now here's the really critical part, and I can't emphasise this enough because I've seen a lot of waivers that look beautifully written, and sometimes a lawyer's taken 5 pages to write what I would have taken a paragraph to write. And they look great, and they're full of legalese, and they look very impressive and probably quite intimidating to anyone who signs it, but they have absolutely no effect. And the reason for that is the waivers can only exclude liability for personal injury or death. They can't exclude liability for property damage. Now that's quite a seemingly bizarre situation where you can get someone to contract out of you injuring them or killing them. So you can render them a paraplegic, or you can kill them, or they can lose a limb, but you can't get out of fixing their mobile phone if it gets damaged in the course of undertaking your activity. That does seem strange, but that is the case. So you've got to be really careful about the way they are drafted. I'll give you some examples in a minute, but certainly going back to the point that Ian raised, the best course of action for you is to get some legal advice on drafting those waivers. It may cost you $3,000 or $4,000, but that's going to save you a lot of money in the long term, particularly if you've got these activities running a lot.
Yeah. Actually, two other questions have quickly just come in, Richard. Both Audrey and also Robbie is out there, and they've asked a question. I think it's both on the same area. Do you require council approval for signage at the entrance of a property? So obviously they're saying it's not their property, maybe it's sort of on council land still, but at the entrance, so it's excluded, not on their land per se.
Yeah, that's certainly going to be a matter for your individual council. The bylaws in each of the councils vary quite considerably, but I would have. It's quite likely that you would. If it's on the outside of your fence or your wall or your gate, I wouldn't have thought so. As long as the sign obviously is not dangerous in and of itself. There's quite a funny case a few years ago where someone tried to run a case about a lack of warning signs on a ferry or a cruise ship, and the judge made some pertinent comments about if we get to the point where we've got too many warning signs, people are going to trip over the warning signs, which was quite amusing, but very much on point.
Just another question on that that you may be able to answer, Richard. With CCTV, are you obligated to have a sign to say that you've got CCTV and you're recording in a park situation or in any situation throughout your own business? Are you obligated by law, do you know, to have a sign that says that you're recording? Or
the privacy, that would be captured by the Privacy Act, and I would say it's sensible to do that, and would be wise to do so. But it's probably good as a bit of a risk management tool in and of itself, because it would dissuade people from making fallacious or unlikely claims if they know that there is some video evidence of them undertaking the activity or doing whatever they've done, perhaps to injure themselves. One thing I would say and emphasise is CCTV footage is not much good if you don't keep it, because I can't tell you how many scenarios I've had where people have actually said, yeah, we had great footage of that, they didn't do what they said they did, or we didn't do what they said that we did. And I say, well, great, can you give me a copy of that? Oh, no, that got taped over. So one thing to do there is, if you do have anyone injured or report an injury, take down some details of that, keep the incident form at the very least, or send it off to your broker or insurer, but also save a copy of the footage that relates to that time as well, and back it up on your hard drive or copy it to a disk or a memory stick.
That's really good advice, Rich. Actually, it's possibly timely to say and to remind everyone right now that this webinar is being taped. And you can listen to it or watch it again on VTIC's YouTube channel. It'll be up there in probably about 48 hours from now. So won't be asking any more new questions, but you can certainly hear your questions being asked because they are being taped. And speaking of which, another question's come through. Thanks, Paul, for coming in. I think we're one of our regulars. Does property loss include theft whilst on a tour?
Yeah, yes, it would. Yep, so that's something you've got to be careful not to try and contract out of, because, again, it's going to render the waiver, which would otherwise have effect, void. But obviously, theft is it's just going to be captured by the general law, which is you need to take reasonable precautions. And reasonable precautions, I mean, it's something you could warn against, but you can't contract out of by way of the waiver. So you could certainly post signs that advise people to keep wallets and mobile phones on their person and not leave them in the car or not leave them lying around. But you wouldn't include that in your waiver because that's where it's going to give you some issues. Now, one more key warning or key provision that you should be aware of with waivers is they won't operate where there's reckless conduct. So reckless is something that's a lot worse than negligent. So it'll cover for negligent conduct, but not for reckless conduct. So if you knew of a risk of something and just didn't care about it, then that could give you some issues. I had a scenario where a slightly different situation, but it was in a motor race and a car had broken down, and rather than take the car off the course altogether, they parked it in a place where someone was, if they went wide in the corner, was quite likely to hit, and that was one where we were concerned that the statutory defences wouldn't help us because that was at a level that was dangerous. That was actually creating the risk rather than failing to warn of it.
Is there a with waivers underage? Is there any issues around people being under the age of 18 and how that stands up in a court?
Yeah.
And do they need at what point do they need a guardian to sign that on their behalf?
Yeah, waivers with people under 18 are problematic. It's not an easy question to answer because there is no clear guidance from the courts on this. Someone who is under 18 can actually be found to have understood the risk that they're participating in, and if that's the case, a risk warning can have effect, and arguably a waiver could have effect as well. So generally speaking, someone under 18 can't sign a binding contract, but in certain circumstances they may be found to have capacity, so they're old enough to make a decision to sign a waiver. There's a case in New South Wales with someone who was paintballing, and the court found that it was very much the case. And I think the child was actually a bit younger, I think about 14, but the court found that they fully appreciated the risk of injury. In this case, I think it was tripping over a tree root while they were running around. And in that case, they found that the warning had effect. It's a very good question. There is some possibility too that, and again, you would want to get legal advice to draft something of this nature, that a waiver form signed by a parent could have effect, but it would only be with the parent actually explicitly agreed to indemnify the provider of the service against a claim by their child. And what would happen there would be, arguably the child would sue the service provider, so the recreational service provider, and then the recreational service provider would go back to the parent and say, by agreement, you have indemnified me, so you have to take over the case for me. So it's a little bit of a convoluted process. It's not wholly tested, so it does. I can't give you categorical advice on that, but certainly if you do want to go down that path, again, it'd be good to get some specific legal advice. Okay. Right. So just to emphasise, if the waiver forms includes an attempt to contract out of property damages or loss as well as injury, the whole waiver will have no effect. Okay, it won't apply to the property damage, and it also won't apply to any injury or death arising. So just leave that out altogether. So here are some examples on waivers that would be void. So they would have no effect. So there's one here: I indemnify and hold harmless in respect of or arising out of my death or any injury. That bit's fine. Loss or damage caused to me or my equipment. As soon as you put or my equipment, it voids the whole thing. Here's another example. Excluding claims for death, personal injury, or property damage. That property damage thing makes the whole thing void. Any injury, loss, damage, death, economic loss whatsoever suffered by you, that's okay. Any loss, damage, injury, whether to person or property, that's where we've got some problems. That's going to be void. It's not going to apply. So I've got a question here. Why with excludes equipment? Please explain further. So what I'm saying there is anything that's not related to injury or death, if you try to include that in your waiver, it's going to render the whole thing void. So equipment as in we're talking about the person's own equipment. So, for example, it was their ski poles or their skis or their helmet when they're riding a bike or a motorbike. Damage to that, that's not going to be covered. It doesn't apply. It doesn't mean that use of your equipment renders it ineffectual, but you're not going to get someone to sign a waiver for your equipment anyway. Oh, and there's another question here. Can I clarify how equipment is different to economic loss in that context? So the difference there is the economic loss here, because it follows injury, loss, damage, death, actually is the economic loss to the person. So that, what it means there is the person's ability to earn wages or salary. So if they can't work because they're injured, that's the economic loss.
Yeah. I think Kerry's just asked another question. Thanks, Kerry, for asking these. So can waiver death or personal injury and must not mention anything to do with property.
Yeah, Kerry, you've got it exactly right. It cannot have any mention of property. I can't emphasise this point enough. It doesn't matter how beautifully it's drafted. If it includes mention of damage to property, the whole thing is void and it will not work. It won't give you any protection. It might as well not be there. Okay. All right, so how to get it right, limit the waivers to death or personal injury. Make sure you bring it to the attention of the person who's purchasing the services, okay? Just for chucking a form under someone's nose and asking them to don't bother reading it and sign it. If they then give evidence they didn't know what they're going to sign, that's going to give you all sorts of problems. Use the formulations prescribed by the regulation. There's some details in this presentation about what they are, and you can find those yourselves, and obviously this is available to you. Keep good records, and that's the other really good point. I mentioned the point about CCTV footage before. It's no good if you don't keep it. It's the same with waivers, and I've had the same issue apply. Yeah, they signed a waiver. Okay, can you send me the waiver? Oh, well, we lost that when we moved premises, or we had a bit of water damage and it's gone. Keep copies of it. It's really important to do that.
How long should you keep a copy of a waiver? Is it 7 years, or is it forever, or is it?
Great question. 7 years, I think, is a reference to some of the keeping of personal data under the privacy rules. 3 years is the limitation period in Victoria for the bringing of a personal injury action. So certainly for 3 years. If it involves a minor, so someone who's under 18, it's 18 plus 3, so it has to be 3 years past when they turn 18, even if it happened when they were 11. So if it's a child, you need to keep it considerably longer. And there are some other provisions around that, and the court actually does have some discretion to allow actions brought outside of that period for certain reasons. But certainly, you know, you probably don't have to have the ability to have rooms and rooms of paper or hard drives and hard drives, more to the point of scanned documents. But certainly I think it's prudent to keep at least 3 years for adults and more for children.
Yeah, actually, Peter's just asked a question on that one, Richard, in terms of, do you need to get the paper document, or can you photograph it or scan it or whatever and keep it to that way?
Yeah, scanned would be okay. Scanned would certainly be all right. And realistically, in this day and age, electronic copies are going to be fine.
Sure. And one more question while I've got you there. Renya has asked a question. We own a ski shop. Can we add the equipment they are hiring?
No, you can't, Renya, unfortunately. You need to, if you want the waiver to have effect, you need to restrict it to injury and death.
Can you have a separate waiver outside of, so 2 separate waivers, one for equipment and one for liability?
Yeah, I think possibly you could. Yeah, I think you possibly could.
So you can separate them. So you can. So someone like Renya, for example, who obviously rents out ski equipment.
Yep.
And if the person breaks it through ill-gotten means or whatever, is she covered at all in any way, shape, any sort of?
Yeah, that's a slightly different issue, because what you're doing there is you're not looking to get out of being sued for their injury from your deeds. You're looking to recover from them where they have damaged your equipment.
I think that's where she's coming from.
So it's not a waiver per se. That's actually an agreement on their responsibilities to the equipment that you're hiring. So that would be under the hire agreement, not under the waiver. They would be two different forms for 2 different purposes. What is a really good idea is to have photographs or footage would also do the job, showing where the signs were displayed. And that give some illustration too that people, as well as signing the form, the waiver and the form, were warned by way of signs, and they could be adjacent to rides throughout the park or certainly at the entrance to your park or your facility. And that's really just around evidence. So if we do have to go to court, that assists us in convincing the court that the appropriate precautions were taken and they were in the form prescribed. All right, so we've got a slide here which I'm not going to read through because I don't want to send you all asleep. It looks quite legalistic, but that is actually the formulation that is provided in the Victorian legislation, the Australian Consumer Law and Fair Trading Act 2012. And that actually gives you some guidance, or actually prescribes the words that you should use by way of signs or in the notice that you give to them that is included in the waiver. And this is in the legislation, so you feel free to utilise that. There's no copyright or anything. It's something that the Australian or the Victorian legislative has applied.
And just a reminder to everyone on this one, if I can, Richard, that this webinar is being taped, will be on our YouTube site within about 48 hours or so. So if you do want to read these words or photograph them, and we've gone through to the next slide, you can always get them that way.
There's another question here about assisting guests down the stairs of buses. And I gather they may well be elderly or people with mobility issues. And we say that as part of our safety talk at the beginning of the talk. We don't have a sign, is this okay? Again, I don't see any particular issue with that. And again, as Dave was saying, that's really going to be captured by the Transport Accident Commission anyway. So it's not going to trigger your liability insurance or have any issue there. If you were sued for something like that, the TAC would actually run your defence for you. I've got another question which I'll come to in just a second, but the following slide is also prescribes what you should put down in any notice given to a purchaser. And again, I'm not going to read through it, but you should feel free to use that information, copy it, incorporate it into your forms. The next question here, we have guests who like going for walks on the property, which includes bush blocks with wild animals. What is required, if any, for signage or signed documents? Again, there's some guidance in the prior slide as to how you might phrase that, but certainly if you are concerned about animals in particular, so snakes would be the obvious example, then you just warn them of the presence of those and that they should take due care. I mean, we are living in Australia, and certainly the similar thing for bush blocks where there's going to be maybe some hidden sort of small bluffs or hills. The court certainly does require people to use their common sense, so bringing it in general terms to their attention should suffice in that instance.
Koalas dropping out of trees, that sort of stuff.
That's right. Drop bears in the area would certainly be something you should warn of, or perhaps an angry wombat who's not had enough sleep and is a bit grumpy about it. And we've got another question. Thanks, you will laugh as it is so their dog who is with them doesn't pull them down the stairs. So this is the question about
Kerry's company does or pet tours for people with pets.
Okay, great.
And I saw where she was coming from with this.
Right. So it's not people with mobility issues or
necessarily.
elderly necessarily. It's people with dogs accompanying them so they don't pull them down the stairs.
And maybe Fido's in a rush to get out and see the great outdoors and charges down and mum's on the back with the leash in the hand and well, down she goes.
Yeah, without going into too many details, there's other legislation that actually applies to what I call companion animals, and generally anything that they do wrong goes back to the owner. So they would be having to try and sue themselves, which would be an interesting exercise. All right, so key takeaways. As I said before, keep the signed waivers for at least 3 years, more if they're under 18s. So waivers can apply to death and personal injury, but they cannot apply to property damage, so I can't emphasise that enough. Warning signs should be appropriately specific, so you can't just give a general warning that activities in the park may create a risk of injury. It's wiser to give some specifics about that. So misuse of equipment or using equipment in ways not intended could lead to injury would be a good one. tampering with equipment, such as go-karts, try and make you go faster or something like that. Warnings like that would probably better than very general warnings. Well, certainly,
falling rocks, walking close to the edge of something.
Yeah. There is some risk of injury from you riding with horses. If we've got a pony riding facility, you may fall, or they may scare and run quickly. Something along those lines is probably a bit better than a general warning. One other thing that I should emphasise too is that, and I know this will be a lot of very obvious to all the people who are participating today, because you're in the business of providing activities to people, and your businesses are all about people, is that it's not just about legal forms and waivers. They're there to give you some protection, but it's better often to work with that person, and there may be an opportunity if they have a genuine injury and only want very modest help with some out-of-pocket expenses. We would certainly encourage that you have a discussion about that, ideally in concert with your broker and/or your insurer, just to make sure you do it in the appropriate way, because we can run the greatest legal case in the world with the best silks in Victoria, and that'll cost you thousands and thousands of dollars. And that cost, you may win that case, but you may not get your costs back, and they may be considerably more than 2 visits to the physio, a couple of band-aids, and a day off work are going to cost you. Obviously, we live in the day and age of social media, and as I'm sure are very aware, a lot of damage can be done to your brand and your business by not handling customer complaints appropriately. So be aware of that. A waiver is not going to help you there, and your general customer feedback as well. So waivers are great. They're a really valuable tool in your risk management. They're not the be-all and end-all, and there's plenty of other things you can do to properly manage your risk.
Richard, I've just got a couple of questions I want to ask you. I've got a couple of clients myself, Dave from Adroit here, that heavily rely on warning signs, but no waivers. They run centres that attract children from the age of 2 to 15, predominantly.
Yep.
Are they exposing themselves there? They don't have waivers signed at all. They have an introduction video. They have signs out on the courts everywhere on every single piece of equipment. They also have stringent testing of the equipment. It's all documented. Yeah, they do. Their setup is done very well. It's all documented, date stamps, filed away, but they don't have waivers simply for the fact of there's a lot of people coming through the door.
No, that's actually a very good question. Waivers are not the be-all and end-all, and they're not the only way that you can maintain a defence. So in the instance that you're talking about, there is some additional provision in the legislation that says if a risk is obvious, so it's something that's clear to someone using common sense, and that risk manifests an injury, that doesn't mean that you're liable. So in the circumstance you're talking about, the warning signs would be enough to bring it to someone's attention, and could well assist them in avoiding any liability.
And they have the videos playing. So it is a centre that is obvious. If you come to the centre, potential injury is going to happen. You can't just walk into the centre.
Yeah, that's right.
So you're paying, you're getting a wristband, and it's explained, and there's signs everywhere. So
So Bounce, the trampolining park, actually ran a case, which is a reported case. I'm certainly not providing any confidential information, and they did something of similar nature, provided appropriate warning signs, and that was enough for them to avoid liability.
Actually, Rupert's just come through with a really good question. Thanks, Rupert. And it's all about the signed waivers, and people perhaps objecting to actually signing something, or maybe getting a bit of a scare from them. And ask the question: I mean, any tips on getting through the process of actually getting a waiver signed by people?
Yeah. You can't force people to sign them, obviously, and in some instances it's really a matter for you as to whether you are happy to take the risk on letting them participate regardless. As I said, it may help to explain to them that the waiver is not going to protect you if you do anything really reckless. It's really just to protect you for any almost inherent risk in the activity. It may be the situation that you decide that you'd rather they not participate and lose that custom than otherwise. You could also, obviously, as I said in response to Dave's questions just before, sometimes the warning signs may be enough to give you protection in certain instances. And certainly when you've got a lot of children running around, like a childcare centre or a child activity centre, the warning signs are probably a better solution than waivers.
Is it a red flag, potentially, those people that balk at signing a waiver, that they might be the ones that are looking for an easy claim, just off the cuff, maybe turning them away is the right thing to do?
Yeah, it could be. I mean, that's really, it's difficult to give general advice on that. It's a judgment call that you make at the time. But certainly, if you think that they are looking to manufacture a claim, again, if you've got CCTV footage, that's going to give you some additional protection as well.
Yeah, actually, Grace has come through. Grace actually works with us in the Australian Tourism Accreditation Program, and a lot of camps and school camps as members. So Grace has asked a really good question, which probably actually applies to a number of people who look after any school excursions or school groups. And she asked, if a child on a school camp is injured, would the school on the camp or activity be responsible for the liability, and who should provide the waiver to sign?
Yeah, it's a really, really good question. The short answer is both of them, because the liability would arise in slightly different circumstances. The school's obviously got a very high responsibility towards children under their care. So to use a Latin phrase, they're in loco parentis, so they're in the position of the parent. If a school was to be sued, it would be in the nature of failure to supervise appropriately, or if they engage the services of a camp where the activities were not of a suitable level for the child. So they're getting 6-year-olds to abseil, to use a slightly ridiculous scenario. If there is an issue with the equipment in the camp or the way the activity was run, if it's run by the staff of the camp, that's where their liability might arise. And that's where their waiver should be aimed at.
Just another question from me, Richard, and it's just general speak in some respect. Just your views, and I know you posted something not long ago on LinkedIn around some of these frivolous claims that are coming in, and the insurers either defending it or looking at versus the commercial payout, and I guess your views on making a stand on some of these issues, because we often see that claims are paid to make them go away, and it might be 10 grand, 20 grand, versus the spending 100, 200, 300 grand defending it, but making a stand for future claims and moving forward. Just your views on that, or your take on that?
Yeah, look, it's a vexed question. I mean, I've been involved in taking a stand on a couple of claims, but generally they've been where we've actually attempted to try and negotiate a compromised settlement. So it's not necessarily going away money, but it's certainly trying to hedge against your risk. Because if you do lose, you can lose really big. So certainly you really need to pick your battles. You need to be very selective in the cases that you do run as a defence. It's also probably an easier exercise for a large entity, and I'm thinking Woolworths or Coles or people like that, very big companies, to take a stand and make a point, than it is for smaller independent companies to do that. The reality is a lot of these personal injury litigants don't have any assets. They don't live. They may not own a house. They may not even own a car. So if you win your case and you try and get your $100,000 of costs back, they won't have the money to give it to you. So you just have to really look at the costs. And the calculation changes a little bit depending on the potential for the claim. So if it's a terrible claim and they want $500,000, that's one that you would certainly run, and you can make a point out of that. If they had a 50-50 claim and they wanted $50,000, it's hard to make a case to run that claim and defend that claim.
Absolutely.
All right, I might hand over to Dave to give you a quick snapshot on another issue that you would face.
Thanks, Richard. I'll just take 5 or 10 minutes just to gloss over another aspect of insurance cover that some of you may be aware of, some may not. It is a complex section of an insurance policy, so it's going to be a gloss over and a brief introduction and touch point. But quite relevant for SME business. A lot of SME perhaps think that business interruption isn't suitable for them and too expensive, but the stats that I'm about to go through actually pinpoint that it is quite relevant, that larger companies often don't take business interruption for the reason that they've got a pool of money to be able to satisfy themselves in the event of a large loss. But SME businesses, rely on their income and stability to be able to continue to trade throughout an uncertain period. So it's quite relevant for SME business. And the stats out there that QBE has just released show that a lot of businesses don't understand what business interruption can provide. And there's many aspects to it. So I'd encourage you, if it's something you don't have or do have and don't understand properly, to contact us at Adroit, because it is pinpointed at certain businesses. It's quite different and variant throughout each individual cases. So a quick introduction: the ability to continue to trade matters in business, irrespective of what's going on inside or outside the office, shop or warehouse. This need for the certainty in an uncertain world is felt most acutely by small business who must plan their futures without the breadth of supporting traditionally enjoyed by larger organisations. So business interruption insurance deals with the continuity of income after an insured's property is damaged or lost after an unexpected event. It can be a powerful solution in this environment of unknowns. Its ability to deliver continuity of income after an unexpected event is transformative. So QBE's recent commissioned research has revealed that only 17% of small businesses currently hold business interruption insurance. As a result that's likely linked to a lack of understanding and knowledge of cover or appreciation of the financial impact that an interruption to the business can have.
Dave, Andy, what sort of things can business interruption cover? I'm not too sure exactly what it's all about either.
Yep. So, which I'll move on to now. I've got some really good examples here. So, a metro retailer's ability to trade is severely impacted when a water main bursts outside its premises, cutting off access and reducing customer traffic and causing takings to drop for weeks on end while the council attempts to find the fix. So that could be an indirect impact to your own property, but there's an impact to your customers getting to your business by way of access.
So in other words, there's no water damage to their property at all, no flood damage, no nothing, just people can't get in.
Correct. Prevention of access is an extension under the policy that would pick up cover. The premises and stock of a regional supermarket is destroyed in a fire started by a just installed faulty fridge, putting the future of the community critical business at risk. So again, a major impact of a fire to a business, a storm damage to a business, a truck running through the front entrance. There is an excess usually of a 2-day waiting period. So the first 2 days generally is not covered by this policy, but thereafter you can. It's looking to protect the main source of income, so you can keep trading and reopen. And in the event of a large loss, it's quite imperative. I think the stats point to 95% of businesses that don't have business interruption that have a large fire, storm damage, that are shut down for longer than 8 to 12 months, never reopen because they just don't have the income at that small level to be able to continue to operate, to keep paying rent, to keep paying the repayments of the mortgage costs, the critical staff that they want to keep that they don't want going down the road to work for someone else. A small family business can't trade as usual when a critical piece of machinery is damaged. There is no more money coming in, but the business must find a way to continue to pay their employees. They're also relying on a steady stream of income to meet their mortgage repayments. These scenarios and others like them are sadly familiar to many business owners. They highlight the need to access a steady income to meet personal and business expenses. Yet with 19% of small businesses admitting to having no business interruption insurance at all, many small businesses are still grappling with the basics of business insurance. What some business owners may not understand is that there are options available for worst case scenario when a business is forced to close operations for an extended period. So we always look at insuring our buildings, our money cover, our glass, our liability, which are very important. But for an SME business where you've poured your money into, people often don't think about, well, hang on, what if I can't trade for the next 12 months or 24 months, depending on the type of style of business that you run. It's to protect your own livelihood and the money that you've poured in, and it could be your mortgage, etc. It's to protect that style of loss. So it's quite integral to how a business will continue to run after a massive impact going forward.
How long can you be out of action, Dave, if you have something like a major fire or or a roof blown off your premises from the storm.
Absolutely. We're seeing a lot of clients now take 24 months indemnity period. So traditionally, 10 years ago, it was always a 12-month indemnity period because more often than not, you could get up and running. There was enough tradies to rely on to get things going. But as we all know, cancelled red tape, regulation, planning. If it's a cat claim, so a whole area of a suburb,
like the bushfires,
bushfires or a cyclone, there's no tradies available. So it could take you 6 months to get someone out, 12 months, 24 months. So these are risks that people are looking at, and even property owners for loss of rent. You can cover your loss of rent because businesses can be shut down for up to 2 years now. We're seeing, especially in a small town. At Adroit, we had a client lose a supermarket in a small town. That town was relying upon that supermarket. It also has additional benefits of things like additional increased cost of working. So that supermarket was able to open up down the road on a pop-up store, but there was additional costs for them to be able to do that. So this type of section covers that style of cost as well. So any additional costs to pay extra rent to advertise that you're opening up down the road. It could be a dry cleaner go down, and they can operate from someone else's premises, another dry cleaning premises, but they've got to do it overnight. So the cost to go to another major dry cleaner to operate, to pay staff night shift, overtime shift, is all covered under this style of section of a policy. So it is critical, if you don't have funds sitting in your business, to be able to keep the business afloat. As I said, 95% of businesses that don't have business interruption, especially on the SME level, will never reopen after a major loss because they just don't have the money to pump into the business to keep it afloat during that time of loss.
Actually, Dave, Peter's asked a question here, asking about, I think it was almost a two-part question, so I'll ask him two parts as I think he's wanting us to do. So a fire down the road hasn't affected this guy's property at all, but Peter's saying, but it affects people from coming to my property. This business interruption insurance could cover that sort of thing.
Again, it's got to be directly impacting. So prevention of access.
Yeah,
although
no access at all.
Yeah, there was some cases, and I could provide these after this presentation. At the Black Fire, there was arguments around, well, no one wanted to go to that region after, so there was still, the roads were still reopened.
Yeah.
But the impact of the bushfire in that region, there was it cut tourism in those regions because people didn't want to go down there because a lot of the infrastructure was burnt out. So there was major cases and major insurance claims that were covered by that. But there are specialists in that field, which is another section that you are covered under claims preparation expenses. So people like Proclaim would be employed to get involved in a complex claim like that.
Yeah, so you can assist for that. Which is great.
Absolutely. So you take 100,000, or depending on the size of your business, you take sublimits to cover specialists to be able to interact with you in that claim and take the running of that sort of claim.
Yeah, because I think that leads into the second part of Peter's question, where he's asking, it's not so much that's covered in case there was a fire, but what about a risk of a fire? And people don't travel because they're warned off from the SES or whatever, saying, oh, there may be a fire, it's a high fire area, and there may be, so people don't travel as a result. And cover for that actually never actually happens.
No, you can't. So insurance is all related to an event. There has to be an event for a trigger.
So it must have happened.
Yep, absolutely.
Not just a risk, so people turned off.
No, it's something, you can't insure everything, unfortunately. So something that may happen that doesn't eventuate, you can't insure against. So insurance relies on a trigger under a fire that's actually happened.
Yep. I think that helps, Peter. Anyway, thank you.
That answers that. Yep.
I think so. But there's another one now. Where do we start? A question we say. Actually, a question via email. Main Street beautification works over an extended period, impacting access to business. The valid continuity of business claim. Question mark. Yeah, so basically I think what that one's saying is that, there are street works, they're going on and on and on. How long
Yep.
do you go for?
Yep. Again, that's a known. So we're talking about roadworks
Or street beautification, tree
Yep.
works, whatever. But I
Yep.
think perhaps the question is saying it was scheduled to go for a week,
Yep.
but it's due to whatever circumstances, it's going
Yep.
on to 3 or 4 weeks,
Yep.
just continuing on.
Yeah, so that's something, again, business interruption won't cover, a known event. So it's got to be a sudden and unforeseen loss. Okay, so something that the council or whoever at the local region is going to do roadworks. There's a case out in Rosanna at the moment where they're doing the rail bridge works and they've shut down the main road. Business interruption won't cover that. It's a known event. That's something the local council should be looking at to
But what about,
talk to you about and afford you money for that.
Although they've said it'll take 1 week.
Yep.
But for whatever reason, it's taken 5 weeks.
No, so there's got to be an insurable event. So it's got to be there's got to be a fire. If the water main caused it, absolutely, and prevention of access, that style of thing. But if it's a known event that's going to take place, you can't. Insurance is sudden and unforeseen loss.
Sure.
Okay. I'll just go over to the next slide. We're getting close to time. So some of the benefits of business interruption cover: personal income may be maintained so the business owners may meet their personal financial commitments, i.e. debts, payroll, lifestyle expenses. Personal income may be maintained so employees can meet their personal financial commitments. Ability to pay ongoing business expenses to help prevent the business from being wound up. Help protect the capital invested in the business venture. Business interruption insurance is often misunderstood cover. Many small and medium businesses overlook it, think they won't need it, or assume that it's part of a business insurance package automatic. That's where you need to come and speak to us. We can give you some specific to your business, and there may be circumstances where you don't need it. So tour and leisure operators out there that rely on lakes or just a general landscape to operate your business, you may not need it, but there are portions of that cover that you may need, which is additional increased cost of working. You may be able to pick up your business and run it from another location within a couple of days, but there may be extra costs to do that. So there are additional benefits attached to that aren't costly that we can talk to you about as well. So please come and talk to us if you've got if you don't understand it or if you want further information, because it is quite a relevant and important cover.
Great, thank you, Dave. And I think that brings us to a conclusion. But hey, I mean, lots of questions have come through. It's been really fantastic. And again, I mean, we'll be putting up the contact details of both Richard and Dave very soon. So make sure you do actually ask any questions at all. But hey, our next webinar, as you know, first Wednesday of every month. So Wednesday the 16th of May. Next month we'll be dealing with our great partner, Monarch Institute, and they've got a fascinating topic: relationships with small business. Competitive advantage. Basically all about how to work with your competitors for advantages for all. Just make sure you get the right insurance cover, I guess, covering on for today. So that's a really good one. Registrations for that webinar are open now. So don't hesitate. We'll be sending out a few reminders as we always do, of course, but it looks like a really, really good one. So I would urge you to register for that one. Lots of other events coming up on VTIC, as you can see on the slide now. Our mixer series continues on. The next two are up there on the screen now. 2nd of May, the first Wednesday of every month, the VTIC mixer series at the McEwer Treasury Gardens on Spring Street. We had a really good number and a great night. The April mixer, this next one promises to be just as good, if not better. So come along there from 5:30 on Wednesday the 2nd of May. And then we're changing venues, so put in your diary now. Wednesday the 6th of June, the first Wednesday of June. The mixer series will happen at the Sea Life Melbourne Aquarium. We're doing both June and July there. Again, promises to be really, really good nights. No PowerPoints, no presentations, just really good networking, discounted drinks, and a really, really good night. And I'd be very remiss in not mentioning, of course, that the Victorian Tourism Conference is coming up. Make sure it's in your diaries, 30 and 31 July. That's Monday and Tuesday down at the RACV Cape Shank Resort. Liv, who our events manager in the office at VTIC, is working really, really hard on bringing you the most compelling workshops, the most compelling presentations we've ever had. Lots of surprises. It promises to be a really exciting and great couple of days. Registrations will be opening for that. Lots more details coming up on the website at the end of this month. So look out for that. And so that basically brings me to merely say Thank you, Dave. Thank you, Richard, once again. And of course, a huge thank you to our digital marketing partner, Webfirm. Tristan's been sitting in the background here doing lots of stuff for us, making sure that we're there. You'll be providing us with the list of all who have attended, the questions have asked, and any other questions that we didn't get to answer, and also putting it on our YouTube site, accessible through the VTIC home page within the next 24 to 48 hours. But Dave, Richard, thank you so much, guys, for your time. We've really enjoyed having you on board, and I think we've had some really engaged people, lots of questions. Any further questions, there are the contact details. These guys know all there is to need to know, so ask away. And thank you very much. And as we close off, VTIC, as we always do, improving the world one webinar at a time. Thank you very much.